I say the problem that we are faced with the Senzo Meyiwa trial was started by the South African Police Service, specifically the ones that was tasked with investigating this crime. And it just, the ordinary South African should feel and must feel that there is a Brigadier Ganinda that is being mentioned many a times, but we don't see him to come and give answers as to why the shoddy investigation work was happening on this docket. I recall, like, some time back, there was like the crime scene expert, Sergeant Musia, who came and said he took photos and did certain everything. But later on, evidence emerged that there was people, at some stage that scene was left unattended. Police officers came to the scene. They went to the hospital, leave a scene unattended into the hands of, I don't know who that guy is, where he fits in. That was already the first critical stage. And I think the defense team at that point in time, they were supposed to hammer on that and to say that these photos are inadmissible, because what these photos are portraying now is after a crime scene was tampered with and not how it looked directly after Senzo Meyiwa was killed. And they were supposed to canvass that hard with the judge, because there was now evidence on the table to show that what is depicted in the photos that is being presented to court and how the crime scene really looked. That was some of the things that is worrying, and I think that, I'm not saying these guys are guilty or not guilty, but this will be prejudicial to the accused in the box. This is a prickly pear that we're dealing with here, and a very dangerous one for that matter, because here now we'll see a miscarriage of justice. And why do I say that? Say, for instance, now we have these 5 accused in docket 363 forced arrest that's currently on the stand, and it so happens that these guys are acquitted. They are acquitted by court. Now the state decides, okay, these guys are acquitted based on the evidence, so it means that we need to now charge the 7 in the second docket. The 7 in the second docket is simple. Their defense is going to be, we gave evidence, we told you there was intruders, we told you who it was, they were in the dock, the court sort of acquitted them. So what must we do? There's nothing more. And then there will also be an acquittal on that side. That's what is going to happen if these guys are acquitted. The mere fact that they didn't join the accused, because if you go further investigate a case, you find further evidence. You just take it and put it in the one docket, and if you have to add accused, we saw with the Tabu Bester matter, accused getting added and removed as the evidence unravels. Why did they not do this in this? Why did they felt the need to open 2 dockets? And that, for me, it shows that there was investigating teams that was specifically tasked to make sure that it looks like they're investigating this case, but actually they are actually derailing the case so that South Africans and the public at large actually know what happened to Senzo Meyiwa on that fateful night. We as public has a right to know what's happening in that docket. And the mere fact that the state is dominance leaders, they can choose which evidence they present to court to actually get a prosecution. That's unfortunately how it works. And you'll have now like Shamila Batoy, she's the NDPP, the National Director of Public Prosecutions. Then you have like what they call DNDPPs that sits below her, like Mr. Chowki and Mr. De Kock. And so the ranks go down. These are the people normally with high-profile cases at the national office make decisions as to how and when they prosecute a docket. So the mere fact that they chose to go with docket 363, they have their reasons why they do that, but they are normally the people that decides who and what dockets to prosecute if it's high-profile cases. Sometimes it can be also in that specific court where you'll have like your senior public prosecutor that decides. But for me, the mere fact that that docket exists, they were not supposed to even have a second docket. They were supposed to take that evidence, put it on the first docket, because it pertains to the same cause of action, and not have these 2 dockets. And the mere fact that they made a decision to make 2 dockets, it clearly indicates to me there's something, where there's smoke, there's something to be checked out, there's a fire. And for me, I felt like that is where the first letdown of the Meyiwa family, of the South African public, and the justice system has happened, where people opened 2 dockets for the same cause of action. And I think that was wrong from them. Whoever made that decision, it was incorrect. Adding of accused persons cannot happen. It was supposed to, just when Judge Rata Mukhatleng took over the matter, they could have said, we want to add other accused to this docket because we started fresh, and add the people that was in docket 375, and they did not have an excuse not to do so. Add them, and then just say, we use the evidence, we transferred. Defense team, you already have this evidence. Although this docket, we're going to combine the dockets. They could easily have combined the dockets and list all of those people that was in the house, outside the house, that they can pick up from the evidence and join them. and they will fall out as the evidence would be presented. For me, if you look at what happened in the first trial compared to what happened in the second trial, their evidence significantly differed as to what they said what happened. Because in the first trial, they could only hear one gunshot. In the second trial, suddenly some of them heard two, some had three, and then they were adding things now. Because they could see already when they were cross-examined on the first occasion, there were certain things that they have to cover up so that it lines up with their previous statements, so that their previous statements become consistent with their oral evidence, and also to see then also what the ballistic experts testified. So they sort of have brought their evidence in line with it. So I don't trust these guys at all that was testifying on behalf of the state. Their credibility to me is down the drain, because clearly you could see that they are protecting somebody that was in that house besides these five guys, because they could make sure that they identify these five guys as the intruders. But already we can see that the DNA said, we're excluding some of these guys already on the mere fact, and they said they were there. So I don't trust what those guys, because it looks like they fabricated the evidence as things goes on. And obviously they have access to the internet, YouTube, so they can easily go and sit nicely behind their computers and watch what was put to witnesses, what did witnesses testify, so that they could actually sort of bring their thing in line. And also how the state operates on giving the defense evidence in an ambush-like style. For me already, that it speaks to a lot of things that raises red flags for me.